Constitution of India, Part 14, Services under the Union and the States, Chapter 1, Services, Article 308 to 313. Article 308, Interpretation. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. Article 309, Recruitment and Conditions of Service of Persons serving the Union or a state. Subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and the conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of any state, provided that it shall be competent for the President or such person as he may direct in the case of services and posts in connection with the affairs of the Union, and for the governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and the conditions of service of persons appointed or such services and posts until provision in that behalf is made by or under the act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of this any such act. Article 310, Tenure of office of persons serving the Union or a state. Except as expressly provided by this Constitution, every person who is a member of a defence service or of a civil service of the Union or of an All India service or holds any post connected with the defence or any civil post under the Union holds office during the pleasure of the President. And every person who is a member of a civil servant of a state or holds any civil post under a state holds office during the pleasure of the governor of the state. Notwithstanding that a person holding a civil post under the Union or a state holds office during the pleasure of the President or as the case may be of the governor of the state, any contract under which a person not being a member of a defence service or of an All India service or of a civil service of the Union or a state is appointed under this Constitution to hold such a post may, if the President or the Governor, as the case may be, deems it necessary in order to secure the services of a person having special qualifications, provide for the payment to him of compensation if before the expiration of an agreed period that post is abolished or he is for reasons not connected with any misconduct on his part required to vacate that post. Article 311, Dismissal, removal or reduction in ranks of persons employed in civil capacities under the Union or a state. No person who is a member of a civil service of the Union or an All India service or a civil service of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges, provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, or it shall not be necessary to give such person any opportunity of making a representation on the penalty proposed. Provided further that this clause shall not apply where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction or a criminal charge, or where the authority empowered to dismiss or remove a person or to reduce him in ranks is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry, or where the President or the Governor, as the case may be, is satisfied that in the interest of the security of the state, it is not expedient to hold such inquiry. If in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. Article 312 All India Services. Notwithstanding anything in Chapter 6 of Part 6 or Part 11, if the Council of States has declared by a resolution supported by not less than two-thirds of the members present and voting that it is necessary or expedient in the national interest so to do, the Parliament may, by law, provide for the creation of one or more All India services, including an All India Judicial Service, common to the Union and the state, and subject to the other provisions of this chapter, regulate the recruitment and the conditions of service of persons appointed to any such service. The services known at the commencement of this Constitution as the Indian Administrative Service and the Indian Police Service shall be deemed to be services created by Parliament under this article. The All India Judicial Service referred to in Clause 1 shall not include any post inferior to that of a district judge as defined in Article 236. The law providing for the creation of All India Judicial Service aforesaid may contain such provisions for the amendment of Chapter 6 of Part 6 as may be necessary for giving effect to the provisions of that law, and no such law shall be deemed to be an amendment of this Constitution for the purposes of Article 368. Article 312A. Power of Parliament to vary or revoke conditions of service of officers of certain services. Parliament may by law vary or revoke, whether prospectively or retrospectively, the conditions of services as respects remuneration, leave and pension, and the rights as respects disciplinary matters of persons who, having been appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India before the commencement of this Constitution, continue on, and after the commencement of the Constitution 28th Amendment Act 1972, to serve under the Government of India or of a state in any service or post. Vary or revoke, whether prospectively or retrospectively, the conditions of service as respects pension of persons who, having been appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India before the commencement of this Constitution, retired or otherwise ceased to be in service at any time before the commencement of the Constitution 28th Amendment Act 1972, provided that in the case of such person who is holding or has held the office of Chief Justice or other Judge of the Supreme Court or High Court, the Controller and Auditor General of India, the Chairman or other member of the Union or a State Public Union or a State Public Service Commission, or the Chief Election Commissioner, nothing in subclause A or subclause B shall be construed as empowering Parliament to vary or revoke after his appointment to such post the conditions of his service to his disadvantage, except insofar as such conditions of service are applicable to him by reason of his being a person appointed by the Secretary of State or Secretary of State and Council to a civil service of the Crown in India, except to the extent provided for by Parliament by law under this article. Nothing in this article shall affect the power of any legislature or other authority under any other provision of this Constitution to regulate the conditions of service of persons referred to in Clause 1. Neither the Supreme Court nor any other court shall have jurisdiction in any dispute arising out of any provision of or any endorsement on any covenant, agreement, or other similar instrument which was entered into or executed by any person referred to in Clause 1, or arising out of any letter issued to such person in relation to his appointment to any civil service of the Crown in India, or his continuance in service under government of the Dominion of India or a province thereof. Any dispute in respect of any right, liability, or obligation under Article 314 as ordinarily enacted. The provisions of this article shall have effect, notwithstanding anything in Article 314 as originally enacted or in any other provision of this Constitution. Article 313. Transitional Provisions. Until other provision is made in this behalf under this Constitution, All the laws in force immediately before the commencement of this Constitution and applicable to any public service or any post which continues to exist after the commencement of this Constitution as an all India service or as service or post under the Union or a state shall continue in force so far as the consistent with the provisions of this Constitution.